We wanted to start off a little bit with Dodd Frank. You're the first state regulator to implement the federal law on the state level. And we're wondering, how did you, why did you go after that in particular? What did your agency find that you thought really needed or had enough teeth in the regulation to be able to go after a company with that law?
Sure. So we've had for a while now an investigation, a matter involving a subprime auto lender out of Long Island named Condor. And when we looked at it for a while, we realized there was some, if you believe our allegations, some real problems there in terms of funds being taken away from customers, and to the tune of millions and millions of dollars. And as we looked at what our potential remedies were to deal with that, we started to get focused on a provision within Dodd Frank that says state bank supervisors, state bank regulators like DFS, can bring actions in federal court to enforce the consumer protection provisions of Dodd Frank, which includes unfair, deceptive practices and abusive practices. So as we looked at it, the Dodd Frank statute offered us the ability to get into federal court, and this company is also operating in 25 different states or 26 different states, so it allowed us to get potentially broader relief. It also allowed us to get damages, discouragement, and other penalties under Dodd Frank that we couldn't get under state banking law. So we decided that this was a good time to bring an action under that somewhat new provision, and it turns out it's the first time in the country that a bank regulator has done that.
In the case of Condor, was that a one-shot type thing, or do you think Dodd Frank is sort of taking off a little bit, trending a little bit more, becoming a little bit more potent among state regulators, federal regulators? I mean, even it's...
We'll see. I mean, I think the jury's out on that. I think it's possible that now that DFS has used this, new route to get some relief, you may see other regulators decide to do something similar. But I think we just brought Condor last week, and it remains to be seen. I think it's not, the case we brought was not a case about a systemic problem within the subprime auto lending industry. It was about a particular problem at a particular firm involving sweeping of accounts. And I don't, it's not the kind of thing where you can necessarily say, oh, because they brought this case, they're going to bring 5 more or 10 more of them. But in general, I think, look, the UDAAP provisions, unfair, deceptive, and abusive practices, UDAAP,
right,
within Dodd Frank, the consumer protection provisions, are meant to be enforced by the CFPB, but also by, where appropriate, state bank regulators and state attorneys general in certain instances. And I think there's no reason in appropriate cases why state regulators shouldn't be doing that.